Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? Thanks for joining me, guys. Make sure to subscribe if this is your first time because I do these videos every single day. I'm still a law student, and this happened during my first internship at a court. A girl, among other people, was charged with drug possession, but because she had thrown away the drugs and the police couldn't prove that she bought or owned the drugs, because it could have been one of the other people as well who still had drugs on them, the judge ruled in dubio pro reo. He then asked if she wants to say/add something, and this girl asked if she can get her drugs back. The defense attorney looked like he was about to get a heart attack. I really don't want to believe anyone is that stupid. Sadly, yes, I've heard of people calling the police for getting ripped off in their meth purchase. Wow. Opposing counsel, isn't it true you hit the victim in the face with a brick? Client, no, Marcus hit him with a brick. I hit him in the back with a piece of wood. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial, a pen rolled off the table and she is bending over trying to reach it from her chair, but the pen was too far away, so she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay, and her response was that she was fine. Her attorney leaned over and said something to her, and she then loudly started complaining about her back and how much her back hurt, but no one believed her, lol. She snapped at the judge and said, "What are you staring at?" Yeah, that's not a good move. A buddy of mine had a case as a public defender. A gal was busted on drug charges and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. Little late to the party, but here goes, and obligatory not my client. Company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing, though we had heard rumblings that the COO was rather hands-on with the work and with female employees. Apparently, there was a walkaway package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the question a half dozen different ways, and each time the COO denied any out-of-work contact. Later, we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, "But I never had contact with her. It's not like I delivered the flowers myself." COO got terminated for cause, so no walkaway package. At her request, a woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. Same detectives on my case and this new theft. They fingerprint the guy and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney and he says there's really no way to prove it. However, the tie he chose to wear was a one-of-a-kind street map of San Francisco, and I still had all the documentation to prove it. The district attorney's eyes widen and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. Minor traffic cases can be the worst for this, believe it or not, because they are short and simple and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles an hour in a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those since her driving record wasn't that bad. When I showed up for her, I found out that she had been driving 70 up an unploughed snow lane to get around all the other cars travelling in the lane that had been ploughed because they were driving too slow. I didn't know it was even possible to drive 70 miles an hour on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she did, claimed she'd just forgotten to mention it. Now, maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults, give my honest assessment if the case is even worth doing, and so by omitting that detail, she harmed herself for no reason. At least she took it well and didn't get defensive. A friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asked the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they charging me with assault. I never touched her. I just threw an AC at her. This is bull." Judge rescinded the plea deal because of defendant's attitude/lack of remorse, went to trial, and he got a year in jail. The idea of having an AC unit thrown at me is honestly terrifying. That he filmed his offences for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of the trial. It was a nice quick change of plea that afternoon. So you're saying it's just a prank, bro, isn't a valid legal defence? Not since Prankster vs. Bro in 1986. That's good. That's good. There's so many. My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1000%, even after the real talk I have with him asking him to not hide from me. And to be honest, we go into court and at cross-examination the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys and then going to pick up his kid from school. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex's brother owns a private investigator firm. F***ing idiot. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before because the law said that for his conviction he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. I'm a court-appointed attorney for qualifying individuals in family matters, termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and the Department of Children, Court Services, we have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope, all good, let's get my kids, great. That's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1. That he's no longer working, 2. No longer in the apartment, 3. Doesn't want to have a relationship with guardians despite her kids loving them, 4. Won't send her kids pictures of the toys they miss and can't have, 5. Plans on moving out of state, 6. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant. all in the matter of 15 seconds. I was too shocked to even react. Speechless. Not the image of stability and parental fitness I've been trying to paint since July. Foster/adoptive parent here. The first kid we had, we went to the plea hearing for the biological parents. We were on adoptive track and child attorney recommended we go. They pled not guilty. This was not their first TPR. It was clear the biological dad was on something. Biological mum was newly out of rehab. Biological mum said in court she had to have 8 teeth pulled and would take pain pills. Judge told them if they did not appear for any pre-trial hearing, he would terminate. They did not show up for the next one. Biological mum attorney stood up in court and said her client has not returned her calls since last hearing. We were at a visit 2 days before and I heard CPS tell biological mum her hearing was in 2 days. Judge terminated. All CPS workers were congratulations to us because now we could start adoption. I was so sad. My son is amazing. I could not imagine not showing up for him. I love him so much and it has been years since adoption. I know he was meant to be with us, but that day was truly a sad day. I still get tears in my eyes. Biological mum did not even call CPS for goodbye visit for 8 months. We'd already adopted by then. Thank you for the gold, kind stranger. Thank you for stepping in and giving that kid the parents he needed. Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took to the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favour shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. And he picked the card up and read it. I was expecting he easily walked up or sat down, not that he was stupid enough to actually read something out. I love reading through this thread at all the stories and thinking which of them, if they wrote them into a television show, would be laughed off the air as too ridiculously made up. This one is a prime example. Lol. I wasn't a lawyer in this role, but a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long, drawn-out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior, the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people, and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury, and the couple was adamant they didn't think that them getting back together was a detail any of their attorneys needed to know. Employment case. We got to the deposition of my client and all set up. The first question is, please state your name. The client looks at me and says, can we take a break? We do, and she pulls me out in the hall to tell me she's lied to me about her identity. She's apparently a serial fraudster and has changed identities 7 times since the 90s. She apparently thought the other attorneys had somehow figured it out, and that's why they asked the question. I'm a public defender in an area with lots of meth use. Meth makes most people talk. A lot. So I can't tell you how many clients forgot to mention that they got to the jail still high and called their mom, girlfriend, buddy on the recorded jail phone and not only confessed to the crime, but also brainstorm whatever alibi or version of events I'm relying on to defend them. I was in court once for a school journalism project, and there was a woman in court who had been arrested for weed and crack possession when she came to bail out her boyfriend from a separate arrest. Apparently, he called her from jail and told her to come bail her out and to bring some weed and crack. The guard overheard him, and it was recorded on the jail phone, so they arrested her when she showed up. Wow. Credit card theft/fraud case. When I was a younger lawyer back in the late 80s, I was trying this guy on a CC case, and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how she could be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, because not only does he completely match a description I just gave you, but he's wearing the exact same shirt I sold him. The jury convicted him, and I learned that day to better prepare my clients for trial. I heard of a guy trying to appeal his disability benefit being revoked. He was supposedly a paraplegic, but the opposition had over 10 minutes of video footage of him walking, running, and even jumping over a fence. After the 1 minute mark, the judge said, "Okay, I've seen enough. Please leave." There's a rule you're supposed to follow when questioning trial witnesses, and that rule is to never ask a question you don't know the answer to. Despite this rule, lawyers often ask small, apparently inconsequential questions which are necessary to set the scene, but are so inconsequential or obvious that their answers are fairly presumed. This case was an exception to that general presumption. The defendant was arrested on a warrant and transported to jail. After booking him into jail, the officer returned to his vehicle and discovered a baggie of drugs sitting right in the middle of the back seat. The defendant was charged with possession. At trial, the officer explained that he routinely searches his vehicle before his shift starts and after any time he transports someone in his back seat. The defense attorney tried to poke holes in the story, but the officer's testimony was remarkably consistent. The officer was fastidious about checking his vehicle. The appearance of the drugs coincided with the defendant's presence in the vehicle. Then, as the defense attorney was running out of questions, he threw out the question: was there anyone else in the back seat of the vehicle? It was a Hail Mary. Even when there are multiple arrests, police tend not to transport more than one arrestee at a time if they can help it. There was no reason to believe anyone else could have feasibly been in the back seat with the defendant. Though it's no surprise to you, the defense attorney and prosecutor were stunned when the answer came back as yes. Turns out the defendant was with his girlfriend when he was arrested, and the officer courteously agreed to drive her to her apartment before taking her boyfriend to jail. This fact was not included in the police report. The officer never told the prosecutor, and shockingly, the defendant never told his attorney. There was a palpable pause as this fact sunk in. Since there was another person in the back seat, there was more than enough reasonable doubt. Proofs were concluded, and the prosecutor threw out a half-hearted closing. The not guilty verdict was a given. Because of this case, I learned to never assume a fact, no matter how obvious it may seem. I am actually a lawyer, but I was only watching this trial, not participating. So the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with the pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus, it was an accident and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial, and the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along the lines of, "Thrown, eh?" And the defense lawyer said that due to technical difficulties, he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty. So yeah, I was completely dumbfounded. I couldn't get the file to play. What is it? Video of the incident. Oh, it'll show you didn't do it, right? Yeah. Great. Next file, please. Man, this lawyer gig is easy. This one ended my marriage. Well, it was the start of the end of the marriage. My husband lost his job in the title/mortgage business, applied for unemployment, got denied. I decided to help him with his appeal hearing. I asked him multiple times before the hearing, is there anything you did that caused them to fire you? He says, no, absolutely not. They fired him out of nowhere. Hearing day comes, he testifies under oath that he did nothing wrong, was a good employee, no issues. Upon cross-examination, the other attorney pulls out documents from one of his real estate closings, documents that he forged and backdated. Had to admit he perjured himself. Needless to say, he didn't get unemployment and he didn't sleep at home that night. Now you put it that way, maybe I did hit the car. Simple is good. Wow. Not my case, which is a gift from above really. Civil trial before a jury for injuries and prop damage from an NVA, and punitive damages because defendant was intoxicated at the time of the accident. Let's call defendant DUI. Almost doesn't need to be said, but before DUI ever stepped foot in court, they would have been prepped repeatedly, first for the deposition and then for trial testimony with the standard questions. Were there any prior incidents, arrests, convictions, anything that can be used to impeach any of DUI's testimony, yada yada, over hours. Denies everything and is as clean as a clean whistle. Thus, at trial, defense counsel, DC, puts DUI on the stand to give them an opportunity to tell the jury of their contrition for this one-time error in judgment, describe the difficult time DUI was going through at the time, and otherwise show themselves to the jury as an upstanding member of society in order to reduce punitive damages. It goes well. Then plaintiff's counsel, PA, gets to cross. I'm going to paraphrase what allegedly happened next, which is purely hearsay. PA: earlier you testified that this was a one-time mistake and you've learned your lesson. Is that correct? DUI: yes. PA: isn't it true that you've already been convicted of DUI in another state? DUI sits silent as DC immediately objects, but it's properly overruled and DUI must answer. Since what happens next is impeachment, I'll skip the objections, but suffice to say they were being fired off as rapidly as a machine gun and just as rapidly overruled. DUI: yes. PA: and isn't it true that in your prior DUI a child died? You can imagine what's happening in the courtroom and, most importantly, amongst the jury. And you think it's over. Stick a fork in DUI, it's done. But then, PA goes for the jugular. Do you remember the name of that little child that you killed while you were driving while intoxicated? In my opinion, this question is one for the ages, more powerful than the old, when did you stop beating your wife? Because no matter how you answer, and that is why you never, ever lie to your attorney. I was approached by this attorney to work for him for free to go after smugglers. This guy had been arrested for dumping goods onto American markets that violated trade agreements. In his arrest, a bunch of goods were left in warehouses to rot, and their owners, his clients, were never paid. This attorney showed me that this smuggler had assets and that he had gone to the criminal trial and gotten the judge to set aside $2 million of the criminal penalties to settle his client's debts. He had receipts, invoices, all of the paperwork. He just needed associates to help him take the case to trial. He wanted me to work for free, but he would pay me on contingency once he obtained the verdict. He had 2 other attorneys working for him with the same deal. I worked on the case for a short while, but luckily moved on to other things. The other 2 attorneys worked on that case for over 2 years. At one point, they negotiated a $1.5 million settlement of all claims. The attorney in charge rejected the offer because he was convinced he could get twice as much at trial. In the end, the case settled for $200,000 because none of the clients would enter the United States to testify for fear of being arrested. The 2 associates got $8,000 apiece for 2 years of work.